So this upcoming summer, huh? Honestly, a lot faster than a lot of us were beginning to think. Hey guys, this is Jules with True Crime Reactions. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. So I woke up this morning to a few comments on a few of my videos letting me know that there was a new document in the Idaho case. Now I stayed off of all of that yesterday. You guys saw the video that I chose to post yesterday evening. And if you haven't taken a look at that, it'll be in the description box. It's got nothing to do with Idaho whatsoever. I'm going to start doing a series probably like once a week, or just whenever I see these crazy stories that catch my eye that I want to share and keep my eye on. I'm going to do a quick video and post it just to give you guys the initial rundown about what's going on. That's what yesterday's video was. Two completely different stories, one from New York, one from California, both crazy, insane, and honestly don't know what to think about either. But in the Idaho case itself, we have new documents for the state requesting that the court start the trial scheduling to happen during this next summer of 2024. As you can see here, it states motion for scheduling order, and it is from the state. Comes now the state of Idaho by and through the Latell County prosecuting attorney, and respectfully moves the court for a scheduling order addressing without limitation the following: scheduling a jury trial to run for approximately 6 weeks, which we already knew they originally wanted it to go for 6 weeks, including penalty phase. The state proposes that the court schedule trial for the summer of 2024, and that the trial dates avoid times when Moscow High School and our area universities are in session. That makes actual sense, honestly. As the court is aware, Moscow High School is directly adjacent to the courthouse premises, and already the significantly increased amount of media and other vehicles related to this case has strained available parking as well as safety and convenience for pedestrians, including students. Or how about just the fact that there's probably a lot of crazy true crimers going to that courthouse that are justifiably insane, and that puts actual students in danger? That would most likely be the top reasoning for that, right? And on top of that, there's a lot of questions in this case. So there's a possibility that if someone else is responsible, or if someone else is involved in this situation, they might show up at the courthouse to be in the audience and watch. That puts the kids in even more danger. It's just a scenario. The court is also aware that when the local universities are in session, it is not infrequent for area lodging to become unavailable due to university-related activities such as sporting events, graduation, etc., or parents' weekend. The state also requests that the court set a daily trial schedule of 8:30 a.m. to approximately 3 p.m. That's all day. That's like almost an 8-hour shift. I work from 8:30 to 4:30 or 8 to 4, just depending on what time I want to actually clock in between that 30-minute grace period for a full 8 hours. So yeah, that's like, that's almost the full time I'm at work. For a trial of this length, it's appropriate to afford jurors some amount of time to tend to their personal affairs. You're giving them no time. If they're getting out of court, if court ends at 3 o'clock, they're still having to go through whatever that little procedure is before they get to leave, because they get, well, I guess the judge gives them that whole speech, right, about no media, you can't talk to anybody, blah blah blah, whatever. But they still have to get out of the courthouse. They still have to get to their car. They still have to figure out what they need to do or get to where they're going. Most places close between 4 and 5 p.m. That's not really given these normal citizens time to do a lot of anything, honestly. Additionally, having more time in the afternoon allows for better preparation by the parties and allows for reasonable opportunities and time for the court and counsel to address any motions or other matters that routinely arise during the course of jury trials. In the state's experience, this type of daily trial schedule is typically appreciated by jurors as well as court staff and counsel. I don't know about appreciated by jurors. You're keeping them all day long. They're not getting paid. I don't know about that. Now, see, that was just like their number one, right? They have a whole other list, but this is stuff I remember whenever we were talking about the original trial date for October, there was a session before that, a court hearing before that, where they were going through all of this. And they did deadlines for literally all of these things. And of course we have that motion of limine or whatever, limine, whatever you call it. It's been a while since we've talked about it, but I am still waiting, you guys. I'm still waiting for the state to file this motion that they've promised to file when it comes to, what was it, the IgG not being included or being admissible in evidence. Weren't they supposed to file that motion? But instead, we're doing all of these fights and all of these arguments over the IgG because now we have the in-camera session happening with the judge. And he's now going to have to go through and determine what's really going on with the IgG and look through everything himself to see whatever he's supposed to be seeing. So instead of the state filing the motion of limine to get that just excluded, we're going through all of this, and all these tax dollars are getting paid by the citizens of Idaho to continue a fight that we were already told the state was going to be making sure wasn't even a situation by filing said motion, because they haven't filed it yet. But this is pretty much that exact same deadline situation. The court's August 2023 scheduling order also directed the submission of trial exhibits and names of witnesses. You mean like Bethany Funk? You mean like Enan Harsh? And I meant to talk about this, guys. Most of you guys know about this. For those of you who might not, though, I'm going to go ahead and drop this little tidbit out there. Did you guys know that Enan Harsh was subpoenaed to be a witness for the defense during the preliminary hearing? Yeah, that was interesting when he said that out of his own mouth during an interview. It's been a few months now since I've seen this. I remember wanting to do a video on Enan. There's weird things about Enan. I don't know if he's involved in anything. I don't know if he knows more than he lets on. But I found it interesting that the defense, not the state and prosecution, but the defense wanted to bring on Enan Harsh. But then he's still out here talking sometimes, and like he was giving interviews after the fact. Now I know that he was like dismissed from that because the preliminary hearing became null and void because they ended up doing the grand jury, right? But could he be subpoenaed again? Or is he now talking too much and now he's not a good witness because he's coming out there and he's talking and saying things? I really don't know how that works after you've been dismissed as a witness, especially whenever there's such big potential for you to be recalled as one. I guess we'll find out. It goes on to say the state again requests that the court afford the parties the opportunity to supplement those responses after they have had the opportunity to review and consider the initial submissions of the other party. Speaking of other party submissions, I wonder if the defense ever went and actually interviewed Bethany. We've talked about this before, because whenever all that stuff with Richard Butanti came out about how Bethany had exculpatory evidence, we were being told that Bethany wasn't coming to Idaho. It didn't matter what was said. It didn't matter what the court said. It didn't matter that the courts agreed that if she showed up, then there would be certain things that wouldn't happen to her if need be. Okay, we talked about this months and months and months and months and months and months ago. But we knew that they were supposed to go to her. Have they? And if they did they give the state that information that's supposed to be exculpatory? What was the state's rebuttal to that? Is that stuff that's happening in the background? Because we haven't even seen any sealed documents on that situation since we heard about it. Curious. In its August 2023 scheduling order, the court afforded the defendant an additional opportunity to provide notice of alibi in accordance with court rule and statute. Okay, he gave one, though. The state submits that the defendant has already been afforded this opportunity, and the court heard argument on the motions relating to such. What do you mean, heard arguments on it? But you got it. Like, he handed over an alibi. Remember, he was driving around all night. The state submits the opportunity for the defendant to disclose an alibi and notify the state of the same has passed and ask the court not reopen the issue. Oh, okay. This is a confusing sentence in my, non-legal brain, okay? The state submits the opportunity for the defendant to disclose an alibi. He already did that. But then states, ask the court to not reopen the issue because he already did it, right? Like, that whole sentence seems a bit strange. Notify the state of the same has passed. The state submits the opportunity, but the opportunity has passed, so let's not talk about it anymore. Am I reading? I'm sorry, but maybe it's just a little bit too early. It is literally before 8 a.m. I have not made my coffee yet. Like, most of you guys know, I use a French press. So I pressed my little button on my water boiler little, contraption that I use, and then came in here to do this video before I clocked into my job. So I haven't had coffee. But to me, that sentence right there is a bit confusing. If it would help at identifying dates and scheduling, the state would recommend that the court schedule a status conference on the record. Okay, so the same thing. They want the court to call both sides together so they can discuss in person and in real life, in live action time, okay, exactly what needs to be scheduled and what, so that everyone has their calendars open at the exact same time and can make agreements right there on the spot. Again, the same thing that we saw previously. So what do you guys think? Do you think we're actually going to have trial come summertime? I mean, they've gone back and forth with so many things this entire time. There's really just no telling what's going to actually stick, right? But let me know what you guys think of this timing situation down in the comments. If you liked this video, please not forget to leave a like on your way out and subscribe to the channel if you were not subscribed already. See y'all.